Let's start. The Indian legal system has two branches, that is civil and criminal. Civil law mainly deals with contracts and torts. Criminal law mainly deals with crimes committed against the community. The Code of Criminal Procedure 1973 is a manual for the Indian legal system which deals with criminal law. This article deals with judgments and orders which are passed under the Code of Criminal Procedure. A judgment is a decision given by a person regarding a particular issue. A judgment under the eyes of the law is a decision given by a court of law on a suit which comes up to it. This Code of Criminal Procedure India does not define a judgment, though Chapter 27 of the Code deals with the matter relating to a judgment and its delivery. A judgment can be considered to be the final order passed by a criminal court which may either be pronounced as a conviction of the accused if such person is found to be guilty, or as an acquittal of the accused if such person is found to be innocent. The Supreme Court of India in the case of Surendra Singh versus State of UP 1953 defined judgment as the final decision of the court intimated to the parties and to the world at large by formal pronouncement or delivery in open court section 353. This section helps us understand the process of procurement and pronouncement of a judgment. It says that the pronouncement of judgment in every trial in a criminal court should be done in an open court as soon as a trial subject to the court is terminated. Such judgment should be pronounced by a presiding officer who is in charge of the criminal court of original jurisdiction. Such an officer passing the judgment should sign the transcript and every page as well as the date of the judgment pronounced should be attached to such a document. If the accused related to a judgment is under custody, then such a person should be brought to the court when the judgment is being pronounced. If the accused is not in custody, then his presence shall be demanded by the court at the time of passing the judgment. If there is more than one person, then the absence of any of them will not have any effect in delaying the judgment. Of a copy of the judgment should be made available to all persons associated with the case. The absence of a pleader during the pronouncement of a judgment shall not be deemed to be enough reason for causing any delay in a judgment. Section 354. This section tells us about the language which should be used while pronouncing a judgment. It basically says that unless anything is expressly mentioned under the judgment passed under Section 353, the judgment should be made in the official language of the respective court. This section also helps us understand the legal contents of a judgment para. It basically explains the different instances under which the court passes judgment and the reasons which are required to be given by a court which shall be attached to the respective judgment. Section 355. This section provides instructions which are required to be followed by a metropolitan magistrate while pronouncing a judgment. Section 357. This section talks about the power of the court to demand compensation from the accused with regard to the losses incurred by the other party to the suit. Such compensation may be for the costs of the proceeding, compensation for causing harm, injury or death, etc. There is a particular period of time provided for an appeal against such demanded of compensation by the court once such a period expires. Thank you.